combating impunity through universal jurisdiction. The chair of this panel is Katherine Gallagher. She is senior staff attorney at the Center for Constitutional Rights. She has been the vice president of the International Board of the International Federation for Human Rights. Since 2010, she is member of the editorial committee of the Journal for International Criminal Justice and is adjunct professor of law at the City University of New York. She has an extensive experience in international tribunals, and she will be the chair of this panel. Katherine, the floor is yours.
Thank you. And first, on my own behalf, thank you so much for inviting me to participate in this conference, and particularly in this panel. We're very lucky today to have two practitioners who I think can give us a broad overview of the last 20 years of universal jurisdiction. In 1998, we had the Pinochet moment, and we thought we would have the Pinochet effect. And instead, in the aftermath of September 11th, and how much that may have impacted some of the short-circuiting of universal jurisdiction, we had a number of failed cases. And as efforts to bring powerful to account under universal jurisdiction really took hold, what we saw were changes in law and retreats from national prosecutions. We had a moment also of hope with the ICC that this would be where most of the cases would be heard. And in the last few years, not simply because of some of the challenges at the International Criminal Court, but because of some of the particular circumstances of crimes being committed that maybe are truly beyond the jurisdiction of the ICC, because of where they are taking place or who is committing the crimes, we have seen a certain resurgence of universal jurisdiction. But I think, as we'll hear over the course of the panel from our practitioners, and then from our academic perspective and from our war crimes office, where these cases are getting up and running, we'll have a clearer sense of whether this is truly a resurgence of universal jurisdiction writ large, or whether it is a response to a particular moment. So with that introduction, we're going to start out with Clemence Bectarte, who has litigated a number of universal jurisdiction cases in France, in Senegal, in Mali. She's been at the ECCC, and she'll give us a little survey of some of the challenges and opportunities of this particular moment. Clemence?
Thank you, Katie. My turn now to thank the organizers of this conference for allowing me to participate and to take the floor today on the important subject of universal jurisdiction. I'd like maybe to give you a personal view as a practitioner, having experienced as a human rights lawyer representing victims in universal jurisdiction cases, and to maybe try to answer one of the questions being, where are we now in terms of universal jurisdiction? But first of all, I'd like to flag that it's not a coincidence if we're talking about universal jurisdiction as the fifth panel of this conference. We're having this discussion now because universal jurisdiction is very often seen as the last recourse for victims of core international crimes. It's the narrow avenue, very sometimes imperfect avenue, that victims turn to when all other avenues have failed, and in particular, of course, articulating their quest for justice before domestic courts in the territorial states. I would say that we're in a very paradoxical situation today in terms of universal jurisdiction, where UJ by the numbers is in expansion as a mechanism. What Maximo Langer, in an article published this year, has called a quiet expansion. We indeed witness a constant increase in the number of cases being brought under universal jurisdiction, the number of prosecutions, of trials, an extension of the situation of crimes concerned by these prosecutions, and an increase also in the number of jurisdictions where cases are being brought and prosecuted. and some beginning of geographical extension also of the jurisdiction investigating these cases beyond Europe and Western states. Going back to the numbers, I'd like to go to a report that was published this year by Trial International, which was briefly mentioned yesterday, which is the Universal Jurisdiction Annual Review, with findings for 2018, and I'll go a little bit into the numbers. This report sheds light on 149 named suspects in 15 countries, 18% more named suspects than the previous year, 17 accused on trial, 8 convictions, 2 acquittals, 111 war crime charges, 90 crimes against humanity charges, 15 genocide charges, and 42 torture charges, with a total increase of 30% of the charges brought compared to the previous year. This in itself means something. 2 decades after the formidable hope which arose from the Pinochet case, but also a decade after the major legal and political setbacks that happened in Belgium with amendments to the legislation, and then years later in Spain and the United Kingdom, which happened each time that NGOs with victims, association of victims, had tried to obtain prosecutions of high-level perpetrators coming from powerful states, and namely China, Israel, or the United States. This expansion is due to multiple reasons, and I'll cite some which I think are important. First of all, the increased incorporation of the Rome Statute in domestic legislations, providing for universal jurisdiction over core international crimes in a growing number of jurisdictions. The creation of special war crimes units as a result of an intense advocacy by NGOs, international NGOs, but also victims themselves pressing for the creation of these dedicated and specialized war crimes unit composed of prosecutors, judges, investigators who are having today an increased capacity to handle these by nature complex cases, cases relating to core international crimes, and cases which very often, in terms of investigations, where you have no possible access to the territorial state, which means to design elaborative ways to access evidence. In addition to this enhanced capacity to investigate core international crimes, the multiplication of war crimes unit has also had as a consequence the multiplication of proprio mutu cases that were initiated not after victims bringing forward complaints, but the war crimes unit themselves and prosecutors opening cases on their own initiative. Another reason is the increased knowledge and experience also built on these cases since the last 2 decades. Experience of what has been a success, experience also what has failed, and maybe also a growing conscience among international NGOs of the need to empower victims themselves, affected communities as a whole, to be able to have maybe reasonable expectations towards universal jurisdiction. And the last maybe reason for this quiet expansion is conflict-related migrations, with refugees arriving notably in European states, sharing their testimonies in asylum request proceedings, but also suspects seeking asylum and facing prosecution in countries which provide for universal jurisdiction mechanism, with in parallel enhanced cooperation between immigration authorities and judicial authorities. But is this quantitative approach sufficient to measure improvement, and are we happy with the numbers? I think that we also have to come back to answer this question to the ultimate goal of having universal jurisdiction as a mechanism to contribute to the architecture of international criminal justice. And if we, beyond these numbers, take a closer look at the nature of the prosecutions, the profile of the defendants, the sometimes very weak participation of victims that should be also taken in account as a measurement of the success and of the achievements of universal jurisdiction cases, but also the insufficiency of outreach and communication strategies designed by prosecutorial authorities in the countries where the prosecutions are taking place, When we look at these criteria, we see that we are witnessing a shift from universal jurisdiction as a tool of proactive universal justice, seeking out the high-profile defendants abroad to foster accountability, process more widely in a given situation of crimes, and shifting towards a no safe haven approach model that prioritizes defendants who have a substantial presence in the prosecutorial country, and when there is also low political cost in pursuing these cases, or even political gain in pursuing these cases. This no safe haven approach can be considered as a pragmatic approach, and from the experience I know best before French jurisdictions, this pragmatic approach has led to the sustainability of the War Crimes Unit, to the sustainability and the development of universal cases being brought before French courts because of this no safe haven model that was being developed. But this approach also contributes to the perception of this mechanism as another bias tool, incapable of holding high-level perpetrators to account, not to say those coming from major powers. So I would say that we're today facing a dilemma towards this, yes, quiet expansion of universal jurisdiction. A dilemma for human rights lawyers and from NGOs. Do we want to keep in this pragmatic approach to consolidate the existing cases, to allow, whenever it is possible, victims to be allowed wider participation in the trials, in the investigations, to allow also outreach strategies to be developed around these cases so that they are meaningful, and to be fueling into prosecutorial strategies with weak possibility to influence them? Or do we keep the focus on a proactive approach, empowering victims to design ambitious strategies towards universal jurisdiction and continue also to challenge double standards with the risk of facing the same backlashes as previously experienced, which means political obstacles, political interference into prosecutorial strategies, and also restriction to universal jurisdiction laws. I'll leave it for now with this question. Thank you, Katie.
Thank you. And we will be coming back and doing 2 rounds with each speaker. We're going to shift now over to Alejandro Chehtman from Universidad de Tella in Argentina. And he is going to give us a survey of 3 cases out of Argentina that I think show some of the potential and some of the challenges of pursuing universal jurisdiction. And I just want to pull out a thread that I think will come through all of the speakers, and that's why we're talking about universal jurisdiction. It's not just an end in itself to have a prosecution. It's really to achieve that second goal of preventing crimes. And so that is part of what we are looking to see if that is also achieved, a level of prevention and deterrence through these cases. So Alejandro?
Thank you very much, Katherine. Thank you very much to the organizers as well. This has been a fantastic treat, and I've learned so much in the past 2 days. I wanted to present 3 cases with a particular view on seeing what hinders and what favors the exercise of universal jurisdiction. And there are 3 cases which one of them might be more well-known, but the others might probably not. And these are 3 cases that happened in Argentina before Argentine local authorities. The first one had to do with a complaint made by a victim that just came out of a ship coming from Ivory Coast, and who was interviewed by a prosecutor, and she said that she had been part of, or a victim of crimes against humanity in her home country. Now, there was no civil society involved, no particular appetite of the Argentine authorities to prosecute a case in a country they don't know much about, they don't have easy access, so that case was left at that. Nothing actually happened. The second case, which I think is interesting to think about what hinders and what favors universal jurisdiction prosecutions, is the complaint brought by Human Rights Watch against Mohammed bin Salman when he came to Buenos Aires for the G20 meeting recently. In that case, of course, the judge that received the case had to move forward, but interestingly, he did not choose to claim that bin Salman had immunity from the Argentine domestic courts, as the Argentine government claimed very forcefully before the court. Instead, what he decided to do was to say that Argentine universal jurisdiction is subsidiary on other prosecutions elsewhere, and he requested reports from Yemen, Saudi Arabia, and other jurisdictions to see whether there were being conducted prosecutions against bin Salman for the facts that were presented before him. Of course, he didn't receive the answer in time, and bin Salman left the country without any sort of problems, which shows how subsidiarity in this particular context. Yesterday, we heard from Direct Clady that the duty to prosecute is a crucial in this kind of situations. So subsidiarity in this kind of situations can act as an avoidance technique and a very sort of cost-effective avoidance technique, because the judge didn't have to decide the case on the basis of immunity, which was much less palatable in the context of Argentina. The final case I wanted to bring about is the prosecution of Spanish officials by Argentine first instance judge. And what is interesting there is that when the file was presented, Argentina still has no law on universal jurisdiction. So when the file was complained by a group of victims with the support of civil society NGOs, the first instance judge said, well, I'm sorry, I don't have jurisdiction. And they appealed that decision, and the appeals court said that we have a provision kind of hidden in Article 118 of the Argentine Constitution that provides Argentine courts with jurisdiction over crimes committed against the law of peoples. And they used that particular provision in the Constitution, which had never been used for universal jurisdiction before, even after 150 years after the Constitution was originally passed, with the support of the Inter-American Court of Human Rights jurisprudence on access to courts, to start an investigation. Now, that investigation slightly moved forward, but it faced a difficulty, which is, of course, the non-cooperation of Spanish authorities to prosecute or to advance with the investigation, with citing witnesses, getting a hold of suspects. And what's interesting there is the role of the amnesty, because the amnesty, of course, was not binding on Argentine authorities. So the Argentine courts were not bound by an amnesty passed by Spanish authorities, but it was the reason of Spanish authorities gave the Argentine courts to justify their non-cooperation. So again, a legal argument that it is not an argument that hinders the jurisdiction of the Argentine courts, but it hinders collaboration, and without collaboration, of course, prosecutions for universal jurisdiction can hardly move forward. I think that's for now.
We'll stop there for now, and then come back to you. So we've heard a little bit about amnesties and immunities being surfacing in these cases, whether they're a bar or not. We will see. And I can just say with the MBS case, while it might not have been successful, I think it was successful on some level. The press that got and the momentum that built of maybe having other cases in other places, there was still some measure of success even without an actual prosecution in terms of highlighting the underlying criminal acts. We will turn next to Christian Richter, who's well known to a number of you. He's the head of the War Crimes Unit here in the prosecutor's office in Germany. And we're going to hear a little bit about what's happening in that office and what kinds of cases are being investigated. And I would invite him to, being here in Nuremberg, to channel a little bit of the Nuremberg Principles, and I'm curious how, if at all, the legacy of Nuremberg may influence the way you go about your work.
Thank you, Katie. Thank you very much for inviting me again to this very interesting conference. I'm really honored to sit here on the bench again and tell a little bit about our work. And it's even particularly interesting for me to hear from both of you, and afterwards from Wolfgang, what you think about these domestic cases. I would later on I will ask you if MBS was not invited officially, or this is something I would be interested in comparison how we would handle these cases. Okay, just about the legacy. Well, as you probably know, the Nuremberg military tribunal was not very much recommended in Germany in the 60s and 70s. It was almost, well, maybe forgotten, but it didn't play a role at all during the so-called Cold War. Only in the 90s, when the Iron Fence fell down, and the international tribunals for former Rwanda and for Yugoslavia were founded and came into action. The Germany as well thought about the legacy of the Nuremberg trials, the Nuremberg Military Tribune, and the Nuremberg Principles. And so afterwards, the Nuremberg Principles became part, so to say, of the Rome Statute and of the German Code of Crimes Against International Law as well. So today, for us, it's an obligation to keep in mind what happened in Nuremberg during the Nuremberg trials and where it all started from. And at least in my unit, where we are dealing with international core crimes every day, of course, the Nuremberg Principles are in the background, always present, and are a guiding light for us to go on in our prosecutorial work. Even if we don't think about the Nuremberg Principles every day and in every case. But most of what you can read in the Nuremberg Principle is to be read in the German Code of Crimes Against International Law as well. So what we are doing in our day-to-day work, of course we are prosecuting and investigating international core crimes. Since October 2018, a new second war crimes unit has been founded in my office. The War Crimes Unit of the Federal Public Prosecutor General was divided into two because we became too many people, too many prosecutors to be handled properly. So now we have two War Crimes Units in the Office of the Federal Public Prosecutor General. I'm head of one of these two War Crimes Units, and all in all, we are at the moment investigating, prosecuting in about 80 cases. Half of them more or less, are dealing with the conflict area in Syria and Iraq. The rest is all over the world. Currently we are in, as far as I remember, in 4 trials at the moment, 2 in Düsseldorf, 1 in Berlin, 1 in Stuttgart. We have 2 pending indictments, 1 for Koblenz and 1 for Düsseldorf again. And we are, together with our colleagues from the counterterrorism department, the competent prosecutors in a case which takes place, in a trial which takes place in Munich against a German woman who was with the ISIS in Syria. What is a very interesting case, this is why I tell you this, because it started as a counterterrorism case. My colleagues at the counterterrorism department received information that this woman was involved in the Syrian civil war on the side of ISIS as a wife of an ISIS fighter. She's of German nationality, converted Muslim, and the only thing we knew from her own confession in front of a undercover agent was that they were in possession of a little girl which died afterwards. And we had no idea who this girl was, but after the press release of our office after the indictment, a Yazidi NGO got notice of this case, and they turned to us, telling us that they probably are in contact with the mother of this girl, who was as well a slave in this family of ISIS. And in a very, well, this was just before the beginning of the trial, and our aim was to present this mother as a witness in the trial, and this was a logistical challenge, as you can imagine. This woman was to be located in Iraq and brought to Germany in a very short time, and to be interviewed before, because we didn't want to present her as a witness in the trial as long as we were not, we did not surely know that she really was the mother of this girl. And this is what we did afterwards. We interviewed her, and we from that day on we knew that she is the mother of this little girl, and now she could appear in the trial and testify as a witness more than 10 days, as far as I remember. And from that day on, it became a case of both the War Crimes Unit and the Counterterrorism Department, and even the team is mixed. One of my colleagues is in the trial, and 2 colleagues from the Counterterrorism Department. So this is a very special case for us as well, because it demonstrates that it could work to cooperate Counterterrorism Department on the one side and War Crimes Units on the other side. In the international framework, at least in Europe, I know that there's, you have sometimes rivalry between international core crimes divisions and counterterrorism divisions, and whenever something happens, a terrorist attack happens, all the prosecutors and all the investigators have to leave their unit and have to go to the counterterrorism department, and concerning international core crimes, nothing happens. Okay, let's go back to our work. What might be interesting for you is that we established, even in the department or in the unit of international crimes, the so-called structural cases, which are cases that look on a situation like the situation at the OTP of the ICC. As a whole, we look at the situation with unknown perpetrators, though we probably know, like in Syria, for example, who might be on the top of the list. But it's a structural investigation right from the beginning, normally open to all sides of an armed conflict, for example, or a situation where of great violence, which might lead to crimes against humanity or even genocide. But from our experience, pretty soon these structural cases tend to focus on one side. And then that was the case in our Syrian structural case, which we opened in 2011, pretty soon after the riots in Syria began, under the aspect of crimes against humanity. Then it shifted towards crimes against humanity plus war crimes after it turned to be a civil war. And then we split it into 2 structural cases, one concerning the regime side, mostly the regime side, and a special one concerning what ISIS did. And these were even split it again, because we made another one concerning the attacks of ISIS against the Yazidi population. Background of this is that we have a lot of refugees from the Yazidi population in Germany, so this is a huge source of information for us to interview these mostly girls and women, what happened to them. Okay, and out of these cases we develop personal cases against personal known suspects and try to bring them to court. Well, we have some cases where we have to be very patient if we will get hands on these suspects, because they are not living in Germany, but sometimes it works. For example, this is my last note for now. We succeeded in identifying the husband of this woman, which is in trial at the moment in Munich. And we located this man as a refugee in Greece. And as we had this victim, the mother of this little child in Germany, we decided to take this case as well. So there was not a relation to Germany except for this fact that the victim is in Germany, because this husband is of Syrian nationality and has never been to Germany before. And we asked Greece for extradition in this case, and finally last week this guy was extradited to Germany and will face a trial during the next month. Yeah, this is for the moment. Thanks.
Thank
you. I will come back to that.
And it shows the extent of resources that you're expending on this particular case already, which might take us over then to Wolfgang, who's had his own experience with the German prosecutor's office trying to get cases initiated and sometimes hearing about the resources or lack thereof. So it would be interesting, Wolfgang, if you can take us maybe from your first interventions back in 2004 with the Rumsfeld case to where you're at now with the German prosecutor's office, and if you're seeing any differences maybe. And in surfacing that, I think it's helpful from your perspective to talk about the role of the victims and how you envision these universal jurisdiction cases as a representative for victims.
Thank you very much, Katie, and thanks also to the Academy for inviting me. I would like to take a step back because I feel very much inspired through the last panel. Charles' remarks on the magnitude of the problem we are facing, the challenge of combating crimes that happened on this large scale in conflict, post-conflict and dictatorial regimes. And also Louis' remarks on amnesty is not a strategy but a tactics. Accountability and universal jurisdiction is also not a strategy but a tactics. And so I think this is an important reminder to all of us who we are sitting here, to the international criminal lawyers community. Embed your activities, position yourself and make clear what you're doing, where you are. And I think that's often lacking. And especially in this room, 600, I mean, this was not the only answer to the Nazi regime. There were a lot of more answers. And to point out what happened here as the model, as the only answer, is wrong, is the wrong narrative of the history. The history is much more complex and much worse than several of you, especially from outside, might think. So I think it's a very important to always make clear what accountability mechanisms can bring. And you might, and I agree to Louise in that regard, applying to universal jurisdiction, the strategy tactics, sometimes it might not be the most appropriate tool. It might be, it's definitely not the tool. But on the other hand, no investigation, no truth mechanisms, no accountability or no justice is definitely not any answer. That's a completely wrong answer, and that's the tension where we're moving. And I guess my claim or my remarks would be much stronger if we would have some more people who lived through this violence and who processed it, like survivors community, family members, might have also their answer to Charles. When you are pleading for flexibility and forgiveness, which, you know, I take everything what you're saying, I take it as a very serious answer from yourself, but you might be aware that in many conflict situations, this is the excuse for the elites for not doing anything. So coming from that very abstract level down to what can NGOs, what can the human rights movement do, and there I have a very clear demand, which we are not always complying with. We have to develop a political and a legal agenda also around universal jurisdiction and criminal accountability at all. And I have also Charles' remarks in mind when he criticized the bad marketing of the ICC. I don't think it's only a bad marketing, it's much more than that. It's sometimes a really wrong approach, and it's also a wrong approach what happens in several of the universal jurisdiction cases and around universal jurisdiction. So I have a number of things in mind which we can do better in this regard. And obviously what first comes to my mind is that we have to work more with the survivors and their communities and the family members. And that means that we have to develop, that we have to overcome paternalistic patterns, which are all around in this room, in every, whenever all of us go back to work, we're in the middle of this paternalism, which has been critiqued by a lot of post-colonial theorists. And I mention only two paradigms. One is the civilizing mission. I mean, all of us are on civilizing mission. We educate the rest of the world what they're doing is wrong and we're doing the right. And that brings me to the critique of Macao Moutois, the savages, victims, savers dilemma, where the savages are the others, the victims is then a group we define, and we are the savers. And the only way to come out of it is that we have to not only work on the surface of this human rights violation, but we have to analyze the causes of the human rights violation. And as Louise pointed out, sometimes this makes necessary to understand 100 years of history. And in the case of Europe, it's absolutely necessary to understand and always consider and always have in mind the colonial history of Europe. And this is something the international criminal law community is nearly completely lacking. And this leads to what you pointed out, to double standards. And double standard does not only mean that powerful actors like the Russian generals in Chechnya or like the ones who are responsible for Guantanamo are not being held accountable. It means also our companies which are sitting here in Nuremberg, in Munich, our weapon companies, our surveillance technology companies, which are, fueling all these wars we are talking about. And that means that especially, we need also technical skills, and I'm not pointing to Christian in this regard. That might not be his task. He has a very defined role, and I think if we use international criminal law, we have to be aware of the discourse, of the standards, of the procedures. But us, as NGO actors, we also have to understand the language, we have to use it, we have to know the standards, but we have to do much more, and that is challenge power, and that is not something which is very common in the human rights and the international criminal law community, because sometimes we're extremely close to power, and that is incredibly wrong, and I hope that we can overcome that in future.
Thank you, Wolfgang. That was, I think that just that last comment about power, a power analysis in all of this work of prioritizing which cases and which issues we take up, I think is a very helpful lens to look at this work. I'm going to come back to Clemence, and Clemence, building on this role of lawyers and advocates for victims and the victims and survivors themselves. And I fully echo Wolfgang that we are here as imperfect proxies, as lawyers and representatives of victims in these proceedings. But to the extent that you can bring into the room through some of the cases, some of your victims, and what you're finding in the harms that they've suffered is missing, maybe in the prosecutions that are starting to happen at the national level in war crimes offices, and how you navigate that relationship. And I'm particularly struck by the mention of counterterrorism and maybe an appetite to bring those cases forward. So how do you navigate that?
Thank you, Katie. Yeah, I totally join what Wolfgang just said, and I think that we should always have a victim-based approach towards universal jurisdiction, but also towards international justice mechanism, because otherwise, what does it mean? It's not so I was saying that one of the criteria, going back to this quantitative approach, should also be victims' participation, but much more broadly, should be victims and affected community empowerment to be actors of these cases, to be the ones bringing them, to be the ones designing the strategies, and to be the one articulating this quest for accountability. Because at the end of the day, the victims themselves will be the one bringing back the effect, the perhaps positive effect of these prosecutions into the country where the crimes were perpetrated as a leverage for change, as a leverage to heal a society wounded by mass atrocities. And so I often relate to what Mazen Darwish very often says and continues saying. He's the president of SCM, which is the Syrian member organization of FIDH, and we're litigating a lot of Syrian cases in very close cooperation with him and with his organization. He's saying that justice for Syria will not come out of universal jurisdiction. And he keeps saying it, and we often see the Syrian cases as a success today, as the new Rwandan cases, because we have developed proactive strategies, having cases open in multiple jurisdictions, having sometimes high-level defendants maybe appearing in court soon, having international arrest warrants being issued in 2 European countries against very high-level defendants of the Syrian regime. So this might be talked about as a success, and even though Mazen continues to say no justice will come out of universal jurisdiction as such for Syria. It's a leverage, it's a way, it's a step towards accountability. And I think that as human rights lawyers, our role also towards these cases is to ensure that victims associations, and local civil society is able to play a role and to design these strategies and to be actors. Otherwise, it's just a pleasure for us academics and human rights lawyers to have our day in court.
Thank you. I'm going to come back to you, Wolfgang, and ask if you can just go into a little bit of detail of your cases. And I really am interested to hear the different framing that you had at the start of your UJ work in Germany around Rumsfeld and where you're at today. And I would raise this counterterrorism point as well with you, and if you're seeing how if you can just give us a sense of where you see the potential for a technical success, maybe, and how, as you said, it's a tool, it's a tactic, how you maybe define success outside of the cases when you hit up against walls.
You asked me about 2004 to 2006 and the Rumsfeld cases, whereas I would start in 1998, 1999 here in Nuremberg, because here was the headquarter of the German coalition against impunity, bringing the cases against Argentinian dictatorship perpetrators. And that was a work on request of the Argentinian human rights movement. They came to Nuremberg and asked Rainer Huhle and colleagues, are you willing to undertake the same efforts as in Spain and in France, because from our point of view, from the Argentinian human rights movement point of view, it makes sense. It makes sense. And what sense did it make? It helped them to push their case in Argentina. And their case in Argentina was not only a court case, it was numerous court cases in numerous fora. It was truth trials, it was truth commission, it was then criminal trials, it was combating the amnesty at the national level, at the Inter-American Court level, and so on and so on. But it also was also, and that is very important, it was a struggle outside the courtroom. At the same time, while the lawyers were arguing inside the court building, outside there were demonstrations. There were artists painting on the streets, there were theater performances, and so on. And that was successful. And that is, if I have a model, that's the model. That's the model. And that is the conjunction of very different actors in a country, but very well connected to actors outside of the country, and an interdisciplinary mixture. Okay, but you can also work without it, and that is what we then did in these Rumsfeld cases, where I have to say there was no victims community. You know it better than I, because your organization worked with the Guantanamo detainees. They were shattered, mostly they were shattered individuals, tortured, some of them tortured until they went insane. So it was very difficult and was not really, it was difficult to develop a victim-centered approach. And I would say victim-centered approach where possible, but where not possible, I think the Rumsfeld or the US torture cases were still very important to be brought. So, because I have also an interest to live in a society where there is no torture going on, and I have an interest in the rule of law and human rights standards to be upheld. So, if I don't instrumentalize the survivors, and I hope we didn't do it, it's also important to bring those cases. In the Syria cases, as Christian rightly pointed out, it was just the huge number of nearly 1 million refugees showing up in Germany. There was no way for us not to jump into these cases. And also the same need was seen at the side of the prosecutors. And there it's very interesting because obviously sometimes it sees that we are completely on one page. And it is actually the case to some extent, but sometimes not. And we play different roles. The good thing now here in Germany is that we developed a conversation where it's very clear where they are and where we are. So obviously, I'm not at all happy that they are only investigating the Syrian perpetrators, and none of the cases against surveillance technology export companies was not even opened. Although we think at least one of them would have been worth to be looked in. No case against no armed trader was opened, and so on and so on. So there are differences, and obviously the question is, why are you only investigating Syria, and why are you not taking the conclusions of the US Senate torture report 4 years ago and are investigating against George Tenet and his colleagues from the CIA? Why don't you put the same resources into that? That questions remain open. But the good thing, as I said, we developed a discourse where this is openly discussed.
Well, those are very good questions, and those are actually some questions I have, because as some in the room may know, there is a request to investigate the former director of the CIA, George Tenet, in a German court because of the findings that there was torture found by a US Senate report, and he's put out a book that speaks about his own role in that program. So I do want to get into a little bit of the specifics of that, but I guess to pull it slightly back, but still hear an answer on that, how do you go about the work of your office where you ensure that equal justice is being done, and where there can be then legitimacy in all of the cases that you're doing, rather than even those very legitimate cases being given a political label in some way? So how do you ensure equal access to justice and equal justice?
Thank you, Katie, for this interesting question. I don't know if there's equal access to justice, but because this would mean that we should deal with all the cases. The principle of universal jurisdiction is a principle of the substantive law. What means that, looking on the German Code of Crimes Against International Law, that this code is applicable on all situations all over the world, regardless if there's a link to Germany or not. But this is a matter of substantive law that gives us the possibility to start an investigation without a link to Germany. But on the other hand, there's no such thing on the procedural side as an obligation to start an investigation even then when there is no link to Germany and when we do not have the chance to gather any evidence or to get hands on the perpetrator himself, even only in order to interview him. What means, this is, I think this is the spirit behind the introduction of the Code of Crimes Against International Law, and one paragraph in the German criminal procedural law, which gives us a discretion in cases where there is no link to Germany, that we are obliged to investigate all these crimes, all these cases, where we can gather information in Germany without using the way of mutual legal assistance, and where we don't have to bring in all the evidence to Germany in order to have an investigation or later on a trial. It's very interesting, this discussion, because we have to discuss this always on both sides. You're asking me the question of equal access to justice, and why do we do this case and why don't we do that case? On the other hand, we are always asked questions like, why do you do these cases at all? Yeah, I see my boss, the Federal Public Prosecutor General, was asked by an interviewer of the German newspaper, Die Zeit, I think last week or the week before, why do you do Syrian intelligence service cases, torture cases, like the case Wolfgang mentioned as well, and we bring into court now? Because the crime scenery is not in Germany, no German victim, well, the perpetrators are not German at all, so we always discussing in both sides. Anyway, what we do, and this might be the difference between now cases concerning Syrian intelligence service people and US American intelligence service people, where we have the chance to gather evidence, maybe beside one singular testimony, and where we have the chance at the end of the day to bring the suspects into custody. There we start an investigation, and further on, this is something you have to keep in mind. Well, it's not a condition, but we keep in mind as well where do the cases come from. If this is a failed state, and there's to be seen that nothing will happen at any time, or is it a state under the rule of justice? And I think, well, maybe I can tell this. I think there might be a slight difference between Syria now and the US now, in terms of the rule of justice. And I'm a little bit reluctant to do the job of the system of the judicial system of other states under the rule of justice. Maybe we will do this one day, yeah, I don't know. Maybe there are cases where we will do this. I will not exclude this. But on the first hand, I don't know if we should do, this is completely theoretical, hypothetical, do a case what could be done in Austria. They have a judicial system for themselves, and I don't feel the obligation of the Federal Republic of Germany to work for other countries which are, for which reason ever, reluctant to do the job, the judicial job they can do by themselves. And this might be something that we think about when we decide if we do a case or not. Especially beside the fact that if we have evidence in our country or not. So I don't know if this is satisfying, but this is a little bit something Wolfgang mentioned, is something of resources as well. If we have an overwhelming number of witnesses in Germany that who can tell us about crimes that were committed in their home country, then it's even more successful to start an investigation and to build up a case and to finally bring somebody to court and finalize an indictment than in a case where we just know from media and maybe from NGOs that there were potentially crimes committed by a person, but we don't have the victims in the country, we don't have the suspect in the country, nothing is here. This, is slightly difficult for us, and this is why this article was established in the Criminal Procedural Code, so that we can abstain from starting an investigation in cases where there is no link to Germany except for media reports. Even if this is not satisfying for you.
Well,
Sorry.
Thank you for answering the question. We will come to Alejandro now to maybe give us a little bit of an overview, because I think some of the comments you just made about what evidence is available and where resources are spent, you know, we started out with Clemence mentioning the cases in the early 2000s that seemed to kind of stall the universal jurisdiction practices, whether it was the US or Israeli or Chinese. And we've had a number of, yesterday we talked about fact-finding missions. There have certainly been a number around Palestine, and including the Goldstone Commission in 2009, again in 2014. And we see the cost of not having accountability when you have crimes committed again and again. And I wonder how much that might factor into decisions of whether or not it's time to step in through universal jurisdiction when you see a pattern of impunity. And so I think if we can go to Alejandro maybe to give us a survey of where we are seeing the universal jurisdiction cases where we're hearing that there's a resurgence, and where we still might be having gaps even when governments maybe have participated in programs that they could find some evidence for, but you're just seeing a choice not to investigate.
Thank you. Yes, I wanted to complement a bit of Clemence's initial figures, because I agree with her that and with Maximo Langer and others, that there's a quiet expansion of universal jurisdiction cases. Since 1961 until 2017, there's been 1,873 complaints filed on the basis of universal jurisdiction alone, and 40% of them were filed between 2010 and 2017. So 14% of them have been filed on the last 7 years. Now, when you look at how many of those complaints have actually ended up in an actual case, a completed case, you find that only 61 cases have been pursued to the end. That's not even 61 convictions, it's just 61 completed cases of the 1,873 complaints based on universal jurisdiction. It's also interesting to see against whom these completed cases have been pursued. 50% of the defendants tried come from Yugoslavia or Rwanda. 1/3 of the 61 comes from, were either Nazi Germans or come from Syria or Iraq. And the last 1/4% comes barely from Nepal, Chad, Afghanistan, Argentina, Mauritius, and Tunisia. So they all come from countries who will give them no support, zero support. So they are all politically disenfranchised or political outcasts. A second element that I think it's important to highlight here is that except one case, all the other 61 cases that have been completed in the global north, and mostly against the global south, which I think is another issue that's worth mentioning. As I indicated in the collection of the 3 cases that I presented before, I think the participation of civil society is crucial, and Wolfgang was suggesting is particularly important in cases where the defendant is not an asylum seeker in the country, where the prosecutor office might have other reasons for prosecuting. So in cases of defendants who are not necessarily in the country, or the civil society has a particularly important role to play. Now, to give you a bit of a balance on how I see all these developments. So, of course, there are 61 cases completed. We should not draw from that I think would be the wrong conclusion that universal jurisdiction serves no purpose, because even cases which have not been completed serve important functions. So Katherine was mentioned the Pinochet investigation. So the fact that Pinochet was detained in London, even after the importance of the decision of the House of Lords, not granting him immunity. When he arrived back in Chile, he started to be prosecuted for domestic and international crimes in Chile, and that was probably to a great extent part of the legacy of the Pinochet decision in the UK. Similarly, as Katherine also mentioned, the Bin Salman case in Argentina, although of course was not completely even, you could say didn't even start, had big repercussions internationally for his position and for bringing about attention to the situation. And also Baltasar Garzón's investigation into Argentina, and Wolfgang, you mentioned that as well, the fact that Argentinian civil society sought investigations in Europe on the basis of universal jurisdiction was an important aspect of, or an important condiment of the reasons why Argentine judiciary ended up derogating the amnesty laws passed in the late 80s and the pardons in the 90s. So even failed universal jurisdiction prosecutions can have important impacts. So that's the first point. The second point is that this quiet expansion of universal jurisdiction has brought about domestic legislation incorporating international crimes, incorporating international universal jurisdiction, and it's brought about growing expertise among local judiciaries. And I think that's another thing to celebrate even in the whole context. And the final point I want to mention is that we have to be very careful that attention on universal jurisdiction does not mean or does not entail a withdrawal from the multilateral regimes. It shouldn't be a fallback on unilateralism. And I think I would suggest we reflect on Ambassador Rapp's comments yesterday about the pooling of cases between countries and about the cooperation between countries to prosecute. And finally, with regards to that, I think that we have to pay more attention to regional cooperation and regional universal jurisdiction and the involvement of the Global South in universal jurisdiction prosecutions. Just to mention one last case of Argentina, there have been cases from Argentine judiciary prosecuting crimes committed in Paraguay on the basis of universal jurisdiction, and I think that that's a very promising way forward.
Thank you. And we are going to open this up fairly soon, and I would love to have some voices in the back of the room that we haven't had a chance to hear from in Q&A, so if you want to start thinking about your questions. I'm just going to give one last go down the line to our panelists if there's anything that they'd like to add in reaction to what they've heard from others in a couple of minutes, not more than that, to just kind of wrap up before we open the floor up. So just so you have an opportunity.
Well, I would say that maybe a lesson of this panel is that we could spend a whole conference in talking about what is an achievement, what is a success in terms of universal jurisdiction, but not only actually, and it's an ongoing reflection. It's a dynamic reflection. Maybe the positive side of it is that we're still asking ourselves the question and continuing to ask ourselves the question. And it was, well, yes, funny to hear Katie talking about the MBS case in Argentina, saying it was not successful, but it was in a sense. And Alejandro saying that even failed UJ cases, failure meaning not amounting to a conviction, I guess, contributed to positive developments. And I think we have to keep on measuring also and asking ourselves the achievements, also going back to expectation towards these mechanisms and universal jurisdiction being one of them.
I think Christian is of course right to point to material criminal law and to procedural law, and there is no way that Germany prosecutes situations all over the world. So it's definitely our task, and I think we fulfilled it, to bring arguments why there are territorial or personality aspects in the Tenet CIA case to be investigated here, and there are both. I mean, there have been actions of the CIA on German soil, there was German victims, and so on and so on, but I don't want to go much into detail. But it's clear that that is a task that has been done mainly by us, by the NGOs, because it's obvious that official institutions are not much interested in that. And then it comes to the poor statistics of Maximo Langer. And I would say, yes, it's still a tool with universal jurisdiction, and also the International Criminal Court are still tools which bear a certain potential. But if we are 10 years down the road, with the same poor statistics, that there is nothing else but African perpetrators prosecuted, and also on the national level, the powerful actors are not prosecuted, then I would say it became a failure. And just one last remark to you, Christian. A rule of law state is a rule of law state when it obeys the rule of law, and not when it's labeled as a rule of law state. It's not a ticket, a label which you get, and then you have it forever. You have to deserve it. And I would say it was a system crash when the UK started to torture in Iraq, when the US started to torture in Iraq, in Afghanistan, and elsewhere, and when Europe were accomplices. That was a system crash. And still, this might happen. But then, how do you react to that? And still, the next system crash, nothing happened. No way of criminal accountability, neither in the US, nor in the UK, nor in Germany. And that is against any understanding of rule of law. And how can you point to failed states when you fail that way?
I was going to jump in, but I'm holding back.
Well, I don't point to failed states. I'm just looking at the possibilities and the facts which I found here as a prosecutor in Germany. I don't point at failed states, but I think anyway, I think there is a working and functioning justice system in these countries. And I don't know why Germany is in the first line responsible for jurisdiction over perpetrators coming out of these countries or living in these countries. We can discuss this whole day long. I think we won't. I don't know if we will find a common position. Well. Anyway, what I just wanted to say is concerning your remarks, Alejandro, concerning the numbers. I think the numbers in Germany are not so much different. We don't have all these complaints, but we have a lot of indications. I think they are over the years, at least the last years, some hundreds per year, and at the end we have some dozens of investigations, because most of the indications, that must be clear, are very singular indications of one victim who tells us that he was tortured during whatever war all over the world, and he has no idea or she has no idea who the perpetrator were. They were still living in their home country, be it members of a state conflict actor or non-state conflict actor, and they cannot tell us anymore, and they cannot even describe exactly where it happened and when it happened. These are indications we gather, and sometimes we can put it into a context, and then it might be a relevant information one day, but at least at time now, we just cannot make more than categorize them, and this is not a basis of an individual investigation. It's too vague what the information we receive, and as you say, many of the countries are pretty reluctant if it comes to a cooperation in these cases. I'm completely with you, Alejandro, that we don't have to have a fallback on unilateralism, multilateralism in this case, and in this field of prosecution and investigation is really crucial, and this is why we cooperate with other countries on EU level foremost, but even beyond this, we cooperate with NGOs all over the world. Even with these NGOs, we do not agree always, like ECCHR, but no matter, it's very important to be in contact and to exchange thoughts and to exchange information, of course. Yes, this is what I wanted to add for the moment.
Okay, I'll be brief. So my general point is that the contribution, except for a few specific contributions which have been relevant, I think the general contribution of the universal jurisdiction system has been very weak so far, despite the fact that it's growing in terms of quantity of complaints and cases. However, I also think that we should look at universal jurisdiction in a broader picture. So we should not think that universal jurisdiction should do a significant amount of work in sort of bridging the impunity gap. In fact, I think we should rely more, as we heard yesterday, on domestic prosecutions from the territorial state or the state of nationality of the perpetrators or the victims, the multilateral or international tribunals or hybrid courts like the ICC and the rest who should do much or a significant part of the work on particular high-profile cases, and also international human rights law. International human rights law can be a crucial force to domestic prosecutions. The Inter-American system is a very good example of that. In Peru, in Uruguay, in Argentina, and so on and so forth. So I think we should look at universal jurisdiction in a broader context and see what's the specific, what are we asking it to do in that broader institutional context. And my final point is that we also have to take on the experience we've had in universal jurisdiction prosecutions in Spain and Belgium, which did not end well for universal jurisdiction generally. So I think we have to push forward, but also be sensitive to the limitations of this particular way of seeking accountability. Thank you.
Yeah, I think Belgium and Spain do raise a question. I'm not sure whether it's that we have to be careful about universal jurisdiction or whether it exposes a weakness of international justice, particularly when we go against the powerful. So with that, let's open up and get a round of questions. And again, if there's anyone in the back, please raise your hand so that we see you and can hear you. One over here.
Thank you very much. My name is Inga Kravcik from the Free University of Berlin, and I have two questions. My first question relates to sexual and gender-based violence, and as we all know, they are quite broadly institutionalized in the Rome Statute, yet the implementation of those prohibitions is rather insufficient. Currently, after 17 years of the ICC's functioning, we still have only one conviction of rape and sexual slavery in the Ntaganda case recently in July of this year after the Bemba's acquittal. But however, I think that despite this rather unsatisfactory result, the normative evolution of these crimes recognition by the policy of the ICC, and also that we also can see in its jurisprudence, is significant, such as, for instance, the explicit recognition of the judges of the trial chamber in Ntaganda that the prohibitions of rape and sexual slavery in war use cogent norms of international law. So I've been wondering how these norms, considering the nature of these crimes and its extensive commission, are being implemented through the approach of universal jurisdiction. And the second question is a bit different and probably quite provocative, but since you, Katherine, mentioned Palestine, I'd like to ask probably mainly the German participant since I live in Germany. I'm not German, but I live in Germany, and I'm a fellow of a German-Israeli joint study program. And sometimes I have a feeling that the guilt for what has been done to the Jewish population during the Second World War still hinders Germans in their reaction to the alleged crimes committed or alleged human rights violations committed by Israel against Palestinian population. I just want to hear about your reaction to this perception. Thank you very much.
Thank you. Let's take one more in this round, and then, yeah.
Thank you very much, and I will not ask the question about the power, although that's actually the question I really want to ask, largely because I think that Wolfgang captured it perfectly, and I think for me to ask the question might be actually to minimize the points that he's made. What I will ask Christian, though, concerns the cases that, of course, have made headlines that Germany is involved in, and I wanted to ask, to what extent has the prosecution thought about, contemplated, and consciously made a decision concerning the applicability of immunity ratione materiae, because obviously it applies, and yet these prosecutions are nonetheless happening. So that's the first part of the question, and the second part of the question is how is the position of the prosecution reconcilable with the position of the foreign ministry with respect to the ILC project on immunity, and in particular draft Article 7, which relates to exceptions to immunity ratione materiae when crimes such as these are taking place. Thank you very much. Although let's leave it.
Okay, let's have a minute or two for answers.
Yeah, I can answer to the Israel-Palestine question, and I leave the immunity to you, if this is okay.
Yes. Or both. Or both.
We brought, as you might know, one accusation of war crimes against the Israeli Defense Forces, IDF, because in one incident, a German-Palestinian family was basically exterminated, and so it's not universal jurisdiction, it's also personal jurisdiction. And the way how we conducted the case took into account the place where we are. I mean, Germany is still a special place when it comes to war crime accusation against Israel, and I also plead for reluctance, and that brought us to normally we in most of the cases we go public with the cases. In this case we didn't go public because we didn't want to be a part of this partly irrational debate between people who will embrace us for this action and others who will then oppose them. So we wanted it to be a legal case. So we brought it to the prosecutor's office. The outcome is not very successful, but it wouldn't have been successful either for a number of reasons, because IHL is so weak in the protection of civilian population in this kind of. But it's very clear that you have to be extremely careful, because there is still, and I don't even dare to spell it out because it's so obvious, that there is still a strong anti-Semitism in Germany. And the anti-Semitism is not only the far right. The far right would have taken our case and they would have loved it. But many more people would also have loved it, and they would have used it, they would have built it into their narrative of Israel is just the same kind of, perpetrator state as any other were, and it helps to relativate the German Holocaust. And our organization has a clear politics. We won't be part of that efforts. On the other hand, of course, we try to bring all kinds of cases to the prosecutor's office, so we are pursuing the case. We explained our position to the Palestinian organization, which we are working with. They completely understood it, that to bring such a case requires a different politics around the case than to bring this case in Belgium or in France.
the other question, I don't know, on Yazidi and sexual violence?
Well, I can tell something about this. Well, gender-based violence, sexual violence is a big issue in our cases now, but it's very, as you can imagine, it's very difficult to investigate these cases. You need the interviews, you need the victims to give evidence, to testify. The testimonies are crucial in these cases. And you have to be very careful. You cannot just interview a victim of sexual violence, be it a man or a woman, like any other victim of a crime. And you have to think about this very carefully, how to present this in court, because at least under German procedural law, the defense lawyers are not only allowed but even obliged to ask a witness who was victim of sexual violence as well, and this can lead to re-traumatization and things like this. Anyway, we have made a lot of interviews now during the last years, especially with people of the Yazidi religion who were victims of ISIS. But we also received testimonies from the other side of the torture regime of the Syrian government, who told us about sexual violence which took place in the detention camps of the Syrian intelligence service as well. These in future times, these gender-based crimes, sexual crimes, will be part of our indictments more and more, and we will see how we will deal with these cases in court in order to give to have the balance between the right of the defense to interview witnesses in court and on the other hand, to protect these witnesses and prevent them from re-traumatization and things like this. This is what I can tell concerning this. And but one thing I want to mention. Finally, to understand this, it is pretty new for us in our office of the Federal Public Prosecutor General, who deals with terrorism, espionage, and international core crimes, to be investigate in sexual-based violence. This is something pretty common in a local prosecutorial agency, rape and things like this. But we had to establish this in our office. We were the only unit in the office because in terrorist counterterrorism cases, you normally don't have sexual violence unless they are related to war crimes or crimes against humanity or even genocide. This is what I wanted to mention.
No, it's very interesting to hear Mr. Ritscher's response to the question of SGBVs, and I think that the maybe legitimate precautions that have been just stated by the German federal prosecutor always lead to the same consequences, that these are the forgotten crimes and the forgotten charges in a number of prosecutions. Well, I know that there is, among Syrian civil society and Syrian-affected communities, a real reflection now into how to include these charges in the existing investigations that concern the Syrian regime.
And the second question, did you?
Your question, a very interesting one. Immunity. Our position is pretty clear. We don't accept immunity in international core crimes cases, except on the horizontal level, according to heads of state, prime ministers, and maybe, this is discussable, ministers of defense. So we don't, and even in our cases concerning members of the Syrian intelligence service, who are pretty probable civil servants and acting on behalf of the state. We don't accept immunity, and what might be interesting is we, as you probably know because it's publicly known, we received an arrest warrant from the competent pretrial judge of the Supreme Court against Jamil Hassan, the head of the, well, Wolfgang, please help me, the Air Force Intelligence Service. And we asked for extradition to Lebanon because we got information that he is in medical treatment in Lebanon in a hospital. Lebanon did not say anything concerning with regard to to immunity. They only said, well, we have no information that he's present in Lebanon, what is probably a lie, but anyway. But they did not say anything concerning immunity. They did not argue that this guy is immune and we will not extradite him because of this. What I find interesting personally, sometimes it might give you an information if you don't say something. Position concerning International Law Commission was your question, huh? And Foreign Ministry. To be honest, we have no clear position on this because it's very, well, we have an internal one, but this is nothing I can tell you now. This is the Foreign Ministry is the one who deals with these cases, and we are in a very second row there. We can make consultation with the Foreign Ministry via the Ministry of Justice. But I cannot tell you now in a conference like this what our position might be when we are in a discussion with the Foreign Ministry. We not always agree with the Foreign Ministry, but this is something very internal. Yeah? And this is, I ask for your understanding. I cannot tell you now, and in my position as a prosecutor, what my position in relation to this will be. Thank you.
We'll give Alejandro one last minute, and then because this session is under very tight time constraints with the next panel, unfortunately we'll have to save the remaining questions for the end of the program. So we'll have Alejandro, and then I'll just give a couple of quick remarks to close up. Thank you.
Thank you. Just a quick comment on Larry's question about immunities. I think that we can be sure that immunity relativa materia would not apply, but to this kind of core crimes cases on the Pinochet sort of reasons or the reasons that Leila gave yesterday. But I think one important thing to note now is the recent decision by the appeals court in the United Kingdom regarding Lieutenant General Mahmoud Hegazi, considering that there is a special mission immunity under customary international law. I think that's something that should concern us in terms of universal jurisdiction prosecutions.
Oh, thank you. And I want to thank everyone. And in closing, I just want to remember the name of this panel, which was Combating Impunity Through Universal Jurisdiction. So while we heard a lot about the functions of universal jurisdiction, I'm not sure we heard so much that gives us real belief that what was intended through something like the Convention Against Torture, putting in a UJ requirement, has actually led us to a place of combating impunity. I appreciate the concerns about becoming a war crimes office for the world, but I would just point out in a case like the United States, where we have tried universal jurisdiction in France, Spain, Canada, Germany, and Switzerland, no one answered. And where you have Palestine coming out with report after report of fact-finding missions saying, yes, there are crimes that violate international humanitarian law, and we don't see cases being taken up, there is some question about whether we're successful in combating impunity. But I also don't want to take away from those cases that may truly be beyond the jurisdiction of the ICC, and this may actually take us back to the ICC. So in the case of Afghanistan, which is before the appeals chamber, the pretrial chamber at least found that crimes falling within the jurisdiction of the statute, crimes against humanity and war crimes, had been committed, including by US actors, and that there was no will to prosecute these crimes. So this, like Palestine, which has referred the case, may actually not be your universal jurisdiction cases at this point, but we might need to see that ICC step up and bring some of these cases to work in a system again. So let us see, because right now in the US, we have a CIA director who ran a black site. And when she is a CIA director for a president who has said, I'm going to bring back torture and a hell of a lot worse, it's quite concerning. So let us see if we can find some, not only beyond the ICC, but at the ICC for some of these cases. Thank you.